There's several different types of medical malpractice claims that can be brought in the DC, Maryland, and Virginia area. One of the ones that's not so often thought about is lack of informed consent. What this means is, as a patient, you have the right to know all of the material knowledge in order to make decisions about your care. What does that mean? You have the right to know what sort of procedure is going to be performed, why that procedure would be performed, what it is that your diagnosis requires, and then what the risks are of having that procedure performed. Now, that doesn't mean every possible risk has to be mentioned. However, they do have to tell you all material risks and information. Not only that, they also have to tell you, the healthcare providers, whether or not there are any less risky alternatives that are available to you. A lot of people don't think of this, and there are often several claims that can be brought under lack of informed consent. Now, this is true even if you may have signed a consent waiver. When you go in to have procedures done, people often sign consent waivers, and they think that because simply that they've signed this consent waiver, that means that they've waived consent to bring a claim. That is not necessarily true, and that's why working with an attorney to review the conditions and the terms of that consent waiver is so important, because oftentimes there are things that are left out of that consent form, and you still may have a viable claim.